morning. I think we are live now. Welcome to the panel on non-agricultural GIs. Welcome to this virtual panel, a unique panel. Why? Because it's the only panel that is exclusively dedicated to GIs for non-agricultural products, which is always a passionate topic, and I'm looking forward to a good discussion. Before I give the floor to the speakers and to you, the audience, I would first like to abuse my position as a moderator and also at the same time as the deputy head of unit in GROW F3, and that's the unit in charge of non-agricultural GIs, as most of you will know. And I'll give you a short update on where we are actually with this file, with the non-agri GIs in the European Commission. I will refrain from getting you through the history, because for that we have prepared a background note. There are 3 points that I want to raise now in the introduction. First of all, the Council conclusions of the 10th of November 2020, they are mentioned in the background note. Those conclusions on IP policy indicate that the Council, and I quote, stands ready to consider the introduction of a system for sui generis protection of non-agricultural products on the basis of a thorough impact assessment of its potential costs and benefits. So this is the situation in the Council now. The Council stands ready to consider such a system. More recently even, actually today, a new event will take place. The European Commission this morning will adopt the IP action plan, in which it identifies the priorities for the next years in the area of intellectual property. And there will be a section on non-agricultural GIs, and it will say the following: the Commission will, and I quote now, on the basis of a thorough impact assessment of its potential costs and benefits, consider the feasibility of creating an efficient and transparent EU GI protection system for non-agricultural products. So you see here that this morning the Commission will pick up on the conclusions of the Council and say, yes, we are going to prepare an impact assessment to see whether we can create a sui generis system for GI protection for non-agricultural products. Yeah, this is where we are. So the text is not the Commission will propose a sui generis system for non-agricultural GI products. No, it is that we will start with an impact assessment, and on the basis of the impact assessment, we will take a decision. Yeah. So this was my second point. If during this panel the text will be published of the IP action plan, you will get it. You will get the reference to it. If not, I would advise you afterwards simply to Google European Commission IP Action Plan 25th of November, and you'll find it easily. Yeah. Okay, what are the next steps? The next steps are, first of all, that also today we are going to publish, as European Commission, a so-called Inception impact assessment. Now, what the hell is an Inception impact assessment? An Inception impact assessment aims to inform the stakeholders, the interested parties, about the plans of the Commission in order to allow them to provide feedback. So you are invited, all of you, to give feedback on a certain initiative, and an initiative here is obviously GI protection for non-agricultural products. So that document will be published as well in the course of today, and you will have a month to respond to that. Now, how does that document look like? Well, it's not so complicated. There's a problem definition, there are some options, and there are potential impacts of these options. Yeah. Actually, if you read the background note, you will get already quite a good flavor of how this Inception impact assessment will look like. Now, we will gather feedback within 4 weeks. We have 4 weeks. We will gather feedback actually on the basis of this Inception impact assessment, and then of course we will continue with the public consultation. So there will be a second round of feedback, which will then be a formal public consultation with detailed questions on, if we do this or that, how should it look like? And this is all in accordance with the better regulation rules that you know already from what we have with the Agri GI system, right? Okay, in addition, I should inform you as well that we are having a study ongoing on the monitoring of producers and of the enforcement of the systems of non-agri GI to the extent that they exist in the Member States. Yeah. So this was my general introduction. I hope that is useful information for you. Those of you active in the field, you have to be aware that we are asking you now explicitly for input in the next month and also in the course of next year. So this is your chance actually to make your voices heard. But we start already today with that, with the panel of today. Now we have three very distinguished speakers actually to respond to the questions that you have seen in the background note. First, we will have Anke Moerland, who is an associate professor at Maastricht. Then we will listen to Andrea Laglio, who is an IP lecturer in Sheffield in the UK. And then, as a third speaker, we have Bernard O'Connor. Bernard is Bernard in the first place, but secondly is also a partner in a law firm here in Brussels and professor in Milan. Now, they have been asked to respond to the questions in the background paper. These questions are essentially the following. What would you advise the EC, the European Commission, as a next steps on GIs for non-agricultural products? If we should go for an EU GI protection system, then we have some sub-questions. To what extent sui generis systems for non-agri GIs should be inspired by the GI systems we know for agri products? What are the elements that we should follow from the agri system? What are the elements that should not be followed? What are the challenges for monitoring of producers and the enforcement of GI indications? And what about the future of the national sui generis systems that exist already in half of the member states, right? Okay, now if you would be more in favor of amending the trademark system, how should that amendment look like, and what would be the added value of trademarks in comparison to a sui generis system for GIs? And finally, if the EC should not change its legislation, then how would you actually address the challenges that we set out in the background paper? So first we will have the three speakers. They will speak one after the other for a limited amount of time, 7 minutes, 6-7 minutes. And then we open the floor for interventions. So for that, you either can raise your hands or you can make use of the Q&A box. Don't worry if your question, we will take as many questions as we can, of course, but don't worry if we do not address your questions. You can always contact us afterwards. The questions will be copied anyway, so we might, I don't promise it, but we might get back to you individually as well if that approach. Can I please ask everyone to mute yourself? And please, if you want to take the floor and you are given the floor, keep your interventions succinct. We only have 1 hour. I've spent already 8 minutes now, so I've spoken already too much. So let's roll. Anke, the floor is yours.
Thank you very much, Harrie, for this introduction. I think it was very useful, and I'm very happy to be here today to talk to you. You have asked me particularly to address also the trademark system and how the trademark system can protect non-agri GIs. I first want to briefly present 2 advantages of the trademark system to protect GIs that I find very important. I will use the remainder of my time to discuss 3 possible changes to how we currently use collective marks in the EU to protect GIs. So the first advantage of using a trademark system to protect non-agri GIs is that there is an overwhelming familiarity by producers worldwide on how trademarks are used and can be used to protect geographical indications. Many countries use that system to protect non-agri GIs, both inside the EU as well as in third countries. Also, the scope of protection and enforcement mechanisms for trademarks are relatively similar in many countries and therefore familiar to them. For non-EU producers, and particularly those that do not know a separate system for GI protection in their home country, the EU sui generis system is hence more difficult to use. The second advantage I want to highlight of the trademark system is that it allows to protect figurative marks. I find this important. This is not possible under the sui generis system as we know it now. We see many EU and non-EU figurative signs that have gained a reputation for a certain GI. If a sui generis system is adopted for non-agri GIs, producers would need to protect the indication under the sui generis system and the figurative sign under the collective mark system, like for agri GIs. One system for both presents advantages in that respect, I believe. So these were the 2 advantages of the trademark system that I wanted to highlight, and we can expand, of course, on others during the discussion later. I now want to use the remainder of the time to discuss 3 aspects of the current collective mark system in the EU that should be considered to be adapted. A first proposed change is to introduce guidelines that set out certain criteria that are required also under the TRIPS agreement for a geographical indication. So the collective mark system currently does not stipulate criteria that require the quality, characteristics, or reputation of the good to be linked or essentially attributable to a specific territory. It is exactly this causal link that is at the heart of GI protection and that currently is not reflected in the collective mark system as a mandatory requirement. Here, I'm not in favor that these guidelines reflect a distinction between a closer and a looser link, similar to the PDOs or PGIs. I think producers of GI products should not be required to choose between a closer and looser link, but to define the link, whether in terms of quality, characteristics, and/or reputation. This would be easier also for third country producers of GI products. PhD research within the IPIN Innovation Society project has shown that when registering an agricultural GI in the EU, producers from third countries do not choose the PDO or PGI scheme because of a looser or closer link between the product and the territory. They tend to choose it according to what they are familiar with from their home system and also according to what they think is easier to fulfill. This speaks in favor of guidelines for collective marks that require an explanation of the link between the product and the territory, but not requiring a distinction similar to the PDO or PGI scheme. My second suggestion regards an aspect of the current collective mark system that in practice does not seem to be in line with the law and may need to be adapted. For collective marks, it is not entirely clear who can be the proprietor of a collective mark. In the regulation, an association of manufacturers, producers, suppliers of services, or traders can register a collective mark. So an NGO, a regular body, or an association of traders. But does this also include individual companies? When looking at the register now, there seem to be a few of them. But if using collective marks for protecting non-agricultural GIs, we may need a stricter concept of an association in order to ensure that GIs are not registered by only one company, or an association that does not represent the interests of all potential GI producers. This is important because the registering body determines the product specifications that are to be laid down as part of the collective mark registration. Agreeing on these product specifications is a process of discussion and competition among different producer groups. The organization registering the collective mark should therefore be inclusive for all GI producers. My last and third point of reflection regards the recent judgment by the CJEU in the Darjeeling case. In this case, the court highlighted that the purpose of a collective mark for a geographical indication is different from the function of a geographical indication under the sui generis system. In fact, according to the court, the essential function of an EU collective mark is to distinguish goods or services of members of an association from those of other undertakings, and it is not to distinguish those goods according to their geographical origin. In fact, the court rejected the claim that the protection for the Darjeeling collective mark should also include protection against confusion regarding the geographical origin. If this interpretation prevails, the protection through collective marks is different from the protection through GI's sui generis system. Collective marks only protect commercial origin, whereas GIs protect geographical origin. How to solve this dilemma is open for discussion. One possible way forward may be, but I leave that for later to the discussion, is to use the certification mark system. This is currently not possible according to EU law. The purpose of certification mark, however, is to distinguish goods coming from members of an association. But it's not that, but to distinguish goods or services which are certified by the proprietor of the mark. Certification marks therefore don't have the same function as collective marks and thereby may remedy the problem the court has pointed out. So maybe certification marks are an option for protection of geographical indications after all. And hereby I leave this for the opening statement. I'm looking forward to the discussion later.
Well, many thanks, Anke. I think that was a very clear presentation where you set out the differences between sui generis GI system and the trademark system as we know it. I will not repeat these differences, but I'm very much looking forward actually to your research results. Please do not hesitate to share them with us. We will certainly be in touch after this meeting in the process that we have next year when we have to make this impact assessment, thorough impact assessment even, with the cost and benefits of each system. We will certainly come back to you then. Let's move now to the next speaker, which is Andrea. Andrea, if I can ask the technicians to focus on you. The floor is yours now for the next 6-7 minutes.
Hello, thank you very much. I hope you can see me and hear me.
Perfect. Yeah.
Thank you very much. Well, I support the introduction of sui generis GI regime for non-agricultural products, or rather the extension of the agri-food GI regime to these goods for three main reasons. First of all, the EU is a kind of unique case. So the TRIPS agreement, the Lisbon Agreement, the Geneva Act, as well as all the jurisdictions sui generis GI regime in place, well, at least all the jurisdictions that I know, make no distinction between agri-product. So even that this peculiarity of the EU system is mostly due to specific reasons, but it is hard to find a technical analysis for it. Second, it is known that GIs are conceived as one of a broader EU developmental policy, and the goals of these policies are well known: foster development, sustain local producers, identify and preserve local tradition, encourage sustainable practices. I believe that non-agri GIs can contribute to these goals just like agri GIs. And therefore, this policy goal, the distinction between food and non-agri producers, less and less justifiable. And third, I think we must not forget about the international of the European Union. So the EU has recently joined the Geneva Act of the Lisbon Agreement that includes both AO and GI protection for both agri and non-agri products. So I think that this will make the extension of the EU sui generis GI regime almost unavoidable. So as to the question, to what extent should the system be inspired by the GI regime for agricultural products? Well, I believe the current agri-food GI regime can be applied to non-agricultural products, and some research that I have carried out with my colleagues at Max Planck Institute, I think, confirms this, both from an empirical and a comparative perspective. Of course, we can expect PGI a major role. TSGs, so traditional specialties guaranteed, would probably be useful only in case of generic terms or in cases where protection cannot be granted on the basis of an origin link, but the TSGs are different from the two major schemes, of course. As to PDOs, they are probably harder to apply, but not impossible to apply. And I would like to remind in this regard that in the Lisbon database, there are to date 143 registered appellations of origin for non-agricultural products. So as to the elements of the current GI regime for agricultural products that should not be followed, well, I believe that the general principles of the agri-food GI system can apply. Therefore, radical adjustments will probably not be needed, although more research should be conducted in this regard. And of course, attention must be paid to the opinion of the stakeholders. As to the challenges in terms of monitoring and enforcement, I believe that, again, the general principles will apply also to non-agricultural GIs. Of course, same challenges will apply too. And now it's impossible to provide a complete answer to this question here because the area of monitoring and enforcement is left to national jurisdictions. And this is why there are differences between the member states that reflect the interest and the economic value of GIs in each member state. But just to mention some possible challenges, I believe that promoting common bases shared among the member states would be useful, but difficult for structural reasons. Another issue that comes to my mind is that producers will probably require an effective ex officio protection but difficult to ensure in practice everywhere and homogeneously, at least initially. And finally, of course, a new approach to quality checks and controls will be needed for obvious reasons. As to the last question, should non-agricultural GI protection system continue to exist next to a sui generis EU system? Well, I think that a unitary sign procedure is desirable. However, I believe two things. First, a two-steps examination procedure should exist, like the one we have in food regime. And second, it is advisable that future non-agri GI regulation features some sort of grandfather clause or a simplified procedure like the one that was provided at Article 17 of the old Regulation 2081/1992 to facilitate a smooth and quick transition between the old regimes and a possible future unitary one. So thank you very much.
Thank you, Andrea. Your position, I think, is very clear, but as a good academic, you are sometimes a bit cautious. For instance, when you discussed what in a potential sui generis system for non-agri GIs, what we should certainly not take over, I thought you were a bit cautious. But can you give one element of which you say that should certainly not taken over of the current system? Very briefly, please.
I mean, as I say, I believe that the general principles would apply. So then a lot will depend on, you know, for instance, or should be needed on between the nature of agri and non-agricultural product. Generally speaking, just like it happens in other non-European jurisdiction, I think the general principles could apply. Okay,
so you keep a bit cautious, but obviously we will have an opportunity also with you actually to discuss this further, right? Okay, thank you very much, Andrea. Let's then move to the third speaker, Bernard O'Connor. Bernard, the floor is yours.
Thank you, Harrie. Do you hear me?
Perfectly.
Okay. I'm less cautious maybe than Andrea. And my first and basic point is that we have international obligations in Article 22 of the TRIPS agreement. And not only does that agreement, that provision say that we must apply our GI law to all goods, so not just agricultural goods or wines and spirits, but to all goods. But I think it also indicates that we need to have a sui generis system, because the definition in international law says we must have an essentially attributable test. Now, trademark law does not recognize or does not have any sort of essentially attributable test. And it's not something that is recognized, I think, either in collective marks or in certification marks. So in that sense, we're under an obligation, I think, to go for a sui generis system. I think this is the reason why we have a sui generis system already in relation to wines, spirits, and foodstuffs. So the TRIPS agreement does not make a distinction between goods. And so for us to make an artificial distinction, I think would be incorrect law. And I also think it would be politically incorrect. We have chosen to go down the sui generis road in the European Union. And I think that consistency and political consistency requires us to stay going down that road also for the non-agri. I don't see a political reason why we should make a distinction either internally. And I think that it would undermine our external push for the better recognition of GIs as a separate form of intellectual property and not as a subset of trademark law. So I think our international obligations, both what we must do domestically and what we hope to achieve politically through our bilateral agreements, really require us to look at this from a sui generis point of view. By the way, just a final point on the legal obligations. I think that the European Union is obliged to protect indications. And the 3 forms or the 4 forms of GI law that we have already only protect names. So I think we should not make that mistake in relation to the non-agri. Okay. There's been a lot of talk about the idea that non-agri GIs are inherently different from agricultural GIs, and I don't see this so clearly. I think that we have seen significant innovation in relation to wines and spirits. We can see, and we see regularly, the changes in specification to reflect that innovation. So I don't think the capturing of a tradition through a GI system is an inhibition to innovation or the evolution of that tradition. It is just a capturing of the tradition, but the very idea of tradition is that it evolves and it must be kept alive. Also, I think there has been a criticism of the GI system that it does not, that it is more linked to land rather than linked to craftsmanship. And I think this is not really correct. I think every GI is underpinned by traditional craftsmanship, traditional ways of doing things. And craftsmanship thrives in clusters. And a GI system is essentially a cluster, and a cluster of skills. And so I think in that sense, it improves craftsmanship. My next point is in relation to the sui generis systems inspiring the non-agri system. I would go even a bit further. I think we need a single system in the European Union for all GIs. I see no reason why we currently have 4 different systems. So aromatic wines, foodstuffs, ordinary wines, and spirits. There is absolutely no reason why we can't have a single system. We created a single common market organization for 23 different common organizations of the market. And I think that if we can make a single system to cover bananas and milk, there's no reason why we can't have one for wines and ceramics. A further point, I think Andrea mentioned this, and I think it's important. I think we should retain the 2-step approach. And why? GIs are inherently local. And if the first step is not at the local level, I think that you will get yourself into problems at the union level. So it is better to address many of the issues that need to be addressed in terms of specifications, in terms of geographical area at the local level. I've been involved in 2 applications, one where it required an act of the Parliament to solve an issue about the milk mix, and another that required a trip all the way to the Supreme Court of the country concerned to define the geographical area. So, and I think these are really rather local issues that should be done. I think the existing systems should be phased out so we have a singular system. My final point is in relation to cost. And there has been a lot of talk that says that trademarks are a more cost-efficient way of protecting. I'm not so sure that's correct, but I think my more general point is that all intellectual property has a cost, and the cost relates to the intellectual property or the protection that you get. And so I think trademark protection has a particular cost, and it gives you a particular type of protection. GIs are different. patents are different, and these things. So I think, you know, it's to compare or to make a simple comparison to say one is cheaper than the other is not the correct analysis to carry out. I think you have to make it in relation to the type of protection that you want to create and what you give. So with that, I will end my intervention, and I look forward to questions later.
Well, thank you very much. Interesting as always, Bernard. I mean, I would easily have left you the floor longer to develop other issues as well. But we all have, we promised each other we will all be succinct. I have one question to you, and very sneakily, you can only say yes or no.
I got a break here. I didn't get the question. This is designed to make me nervous.
Or maybe it's a case of censorship, I don't know.
Yeah.
Hello, am I back? Can you hear me now?
Yes,
Yes,
we can.
Well, I just, boom, suddenly I was out of it. Okay, so Bernard, it's sneakingly, you can only say yes or no, but when I listen to you carefully, you say the Geneva Act basically does not allow the European Union in a consistent basis in the future to refrain from legislative reforms, because you say that the current trademark system will not be sufficient to meet the requirements of the Geneva Act, which indeed makes no difference between agri and non-agricultural products. So is your assessment then that if the Commission does, if the EU does nothing, that at some point it will be violating the Geneva Act? And again, you can only say yes or no.
Well, it's not the Geneva Act, it's the TRIPS I'm talking about. And I think that if the European Union does nothing, we are exposed to challenge in the WTO for non-compliance with the with Article 22 of the TRIPS agreement. So yes.
Okay, so but on the basis of Article 22 TRIPS, yeah? Okay. Well, we take note of your position, Bernard. Don't know whether everyone agrees with it, but that may be open for discussion. Now, thanks again to the three panelists, and we are now going to the floor, to the audience. In the meantime, I have received one question on the Q&A. It's from Gordon Humphreys, we all know from the UIPO. Essentially, he is saying, when the legal reform process of the trademark system, the current trademark regulation, was completed, Europe found itself with certification marks that excluded geographical origin aspects. And then the rhetoric question of Gordon is, was this a missed opportunity? Excellent question. And I suggest that we now go to the audience. I have actually three persons already that have indicated that they are willing to take the floor. First of all, I would like to give the floor to Christina Vainica. I don't know whether we technically can do that now. She is in the audience, I've seen. Christina, maybe you can raise your hands.
Can you
the virtual?
Can you see me?
Yeah, I can at least hear you, and I will allow to see you as that everyone can look at you as well. Okay, please go ahead, Christina.
Yes, I'm a policy expert for intellectual property law at the Confederation of Swedish Enterprise, and I'm sure many of you are familiar with the Swedish view on GIs, that we are quite skeptical on a whole. Point on the difference between agri-GIs and non-agri-GIs, because I think there are important differences, and Bernard mentioned these, that we have the situation where we have the soil and the climate, and that is really important.
Now.
Sorry?
You're visible. Just for information, you are visible now.
Yeah.
Go ahead.
Yes, that for the agri-GIs, you have the soil and you have the climate, and that is really important to sort of make the champagne and so on. But with the non-agri-GIs, the most important things are the raw materials and the skills. And as a member of the EU, we are very much for free movement, and skills and raw materials, they can be moved. And even if it's true that Bernd said that we have clusters of knowledge, and we can see that all from the traditional industry of making glass in Venice, for example, but still they can be moved. And if we have a free movement, we don't see why we should limit the non-agri things to a specific region. That's number one. Number two is also linked to sort of what we believe about the economic system, and that is that we have always to balance the freedom of competition with protecting other interests. And when it comes to trademark legislation, the balance is there all the time. It comes to the fact that you have to use the trademark, make actual use of the trademark. You have the system about generating the trademarks and so on to balance off those interests. Where we don't see the same type of balancing in the GI protection system. And for us, that means that we have to be careful to broaden the GI protection too much. So we should really think of it. It is an important system, but it should be used when we really must use that type of system when something else doesn't cover it. And third notion is that the non-agri GIs, they're not without protection if we don't have this generous non-agri protection. So we have, for example, you could use the trademark protection, but we also have rules when it comes to marketing, for example. You can't mislead when it comes to the origin of a product. So if you are saying that, for example, in Sweden, we have this famous Dala horses. If you claim that this is a Dala horse, but it looks like a Dala horse, but it's made somewhere else, you can't do that, because that would be against the rules on marketing and misleading on the geographical origin. So there are other things protecting the non-agri that we want to protect. So those were my points. Thank you.
Okay, sorry. Thank you very much, Christina. I think that was a clear statement as well, and it contradicts a little bit the assessment, certainly of the second and the third speaker. Now let's see what other positions we have in the audience, and I would like to give the floor now to Maurice Kennedy from Ireland, and I will ask the technicians please to give him the floor. Maurice Kennedy. Well, a little break we have now. I don't know why. Maurice, can you hear us?
How's that? Can you hear me?
There we have. All right. Okay.
Can you hear me?
Yeah, I can hear you. And just in terms of organization, the following person that I want to give the floor is Audrey Obar. So maybe technically we can already prepare Audrey for the audience. Yeah.
Okay.
And we can see you now.
Good. Yes. Yeah, sometimes we have a steam-driven broadband down in the southwest or southeast of Ireland, where I come from. So apologies about the connection. Just a couple of points relating to trademarks and trade protection for GI products and for non-GI products. I believe the rationale for introducing a new scheme for non-GI should center around the ability of small producers of not having the resource to be able to protect their brands in international markets. So one of the reasons that I feel very strongly that it should be introduced is because smaller producers, smaller craft people don't have the resource to be able to monitor and police their products in international markets. I know in Ireland we have a number of important craft sectors like Donegal Tweed, Connemara Marble, who are located in very rural parts of Ireland, who provide significant rural employment. Most of their products are exported, and they've been undermined in international markets because of copying, because of counterfeiting, and don't have the resource, as I said, to be able to counteract these copying. So it's doing a lot of damage to key sectors in rural Ireland, and these sectors like Donegal Tweed, weaving, spinning, dyeing, they're specialist craft that have been developed over a number of centuries. Donegal Tweed is going for over 200 years in a very rural part of Ireland, and these jobs that are there are critical. They can't be replaced, and they can't be transferred to other areas of the country. So it's very important, I believe, to have a new system. Maybe the name non-GIs is a bit negative. I'm sure somebody would come up with a better name for them rather than non-GIs. I'm sure there's some brand manager somewhere in the European Commission who will come up with some better idea. The other point, a very strong point, is from the consumer's perspective. If we were to get a system for non-GI products, it would really benefit consumers, because particularly nowadays, consumers want to know about where the products come from, who produces them, how are they produced. So all of these factors, if you like, would align very closely with the proposal to introduce a new system for non-GI products. And I'd certainly, we'd be very supportive here in Ireland, I think, if we could have that system introduced, because it's so important for the rural part of the economy, which makes such a contribution to the Irish craft sector.
Okay, thank you very much. I understand that I cannot be seen, but at least I hope that you can hear what I'm saying. So you very much make a point for small businesses in the rural parts, in particular of Ireland. This is an argument, obviously, that we take into account. But obviously, the question is then, do you really need a sui generis system for? Okay, maybe we should try to find another word for this, non-agri. Yes, that's because we want to make a distinction between agri, which is agri, and all the rest is non-agri, right? But we will think about a more positive word in the future. Let's move on. We have still 15 minutes left. Actually, I wanted first to give the floor to Andrea to focus more on the difference between agri and non-agri products. But I see we have already Audrey on our screens, so it would be a shame actually to go back to Andrea. Audrey, you have the floor now, and then afterwards let's see if we can get Andrea to focus on the differences between agri and non-agri. Audrey, please.
Okay, thank you. Good morning to everyone. Thank you for giving me the floor. I represent the French Association of Non-Agri GI, and as some of you know already, that in France we have already implemented a sui generis regulation on geographical indications. Well, I will not come back to what everybody said, and thank you, Bernard, for explaining the real need of consistency of the EU policy on geographical indication. That's something very important for everybody. We defend a EU sui generis approach on geographical indication, and we have the experience in France of having inspired us on the agro-EU sui generis system in order to draft our law. So what exists already at the EU level can be very useful in order to implement a sui generis system for non-agri GIs. I will just say that, well, there will be some slightly differences according to the specification and the approach, as many of you said, on the skills, on the link between the product, but that there is some further discussion on these aspects. I just would like to highlight 2 points from our experience in France. Because of the real and important legal protection conferred by the GI system, we have already some impacts in terms of legal aspects that give us the evidence that the GI system is much more useful in terms of protection of geographical name and value chain in the territory, because we have the comparison between the trademark system that were used, for instance, for the Burgundy stone. They could not protect themselves correctly using the collective trademark, and using now the geographical indication scheme, they can solve at the moment more or less 90% of the misuse they can find in the French market. So it is very important. We have also some positive impacts, as Maurice said before, on the territories, because of positive impacts on the territories, on rural development, because rural development is not only agriculture, it's also handicraft products. So we defend concretely a sui generis approach and a uniform approach on the geographical indication at the EU level, because there are so many benefits for the territory and the producers. Thank you very much.
Okay, thank you, Audrey, for your position, which is known by us, but it's sometimes good to hear the arguments again. I would now like to give the floor to Andrea, just to focus a little bit more on the differences between agri and non-agri. And after Andrea, maybe if the other speakers would like to come in as well, there is an opportunity for both of you to do that. Just let me know. And if not, I see some hands raised. We will try to see if we can give the floor to other people in the audience as well. Andrea, please.
Yeah, thank you. Well, yes, I heard the speech of Vainika. She touched varying points to clarify things that sure, geographical indications are about soil and climate, but this is maybe a dated vision. Today, they're also about reputation and the reputational link between a product and a place. So many countries, India is probably the best example, but many countries protect non-agricultural GIs more than agricultural GIs. So if it was all about soil and climate, I wonder how they do it. And after all, we also protect products which are terroir based. The typical example is, for instance, bakery products and bakerwares. This explains the success of PGIs for their protection. And some national courts, for instance, some Italians have stated that this product actually can be virtually replicated everywhere if it GI protection. So they're not terroir based. I, of course, agree that the skill and traditional know-how is one of the elements that characterizes non-agricultural products. But I would like to remind that GIs protect indications, names, not processes. So, and after all, the of a production does matter. So, for instance, I believe, I don't know, a Stradivari violin from Cremona may be replicated similarly, where yet its tradition and its reputation is rooted in a very specific area. I, of course, see that non-agricultural GIs require an additional amount of flexibility, but I think that the history of agricultural GIs that we can manage that flexibility. So, for instance, specifications can be drafted in specific ways. We have guaranteed if anything else works. And lastly, although they are pretty rare at the moment, we do have multi-country GIs in case there is sort of traditional heritage, let's say, that it is shared among more than one country. I wanted just to clarify this few points in case it helps. Thank you.
Yes, thank you, Andrea. Yes, it certainly helps. We have to be specific here, but we also have to listen to all positions that we have, and we certainly will as European Commission. It's 11:21. We still have 9 minutes left. I see that we have 2 requests from the floor. So that is Eric Teveno, who will speak first, and please keep it succinct. And then Paula Zito will get the floor as well. And then we have Bernard who wants to come in again as well. So first, the floor now to Eric Teveno. And we are waiting for Eric. Yes.
Yeah. Good morning to all. Just very briefly, I wanted to.
Eric, maybe please first tell the audience who you are briefly.
Sorry, I'm Eric Teveno from the Swiss IP office, so the Council for Geographical Indications. I just wanted to shortly to complete or to build on what has been said by Bernard O'Connor, that there are good reasons and even legally binding ones to introduce GIs for all products. And I invite all the participants to this panel to see the presentations that were made yesterday at the SCT information session on geographical indications at the WIPO. Everything is available online, and in particular in the presentation that was made on the Swiss system for appellations of origin and geographical indications. There are 3 slides explaining the differences between GIs and trademarks. I think they would be interesting for many people in this panel. And just two short remarks. The first one is that for sure craftsmanship can move, and I've always moved in the history of the human societies. But the very question is not about that. The very question is why the use of geographical names should move also. And this is, this is an issue in Switzerland when considering Swiss watches, which is a very important industry for Switzerland. And we see no reason why watches that are not made in Switzerland according to that tradition and that cluster of knowledge and so on could be labeled as Swiss watches anywhere in the world. But for sure, we would not, we would never prevent anyone anywhere in the world to produce watches or even very good watches. The only thing is that the name Swiss should not be used. And my last remark would be that the general provisions of misleading against the misleading of the consumers and unfair competition, for sure they are available to protect all indications of source, as the GIs, the registration of a GI is an exception to that principle of free use of geographical names, because they are in the public domain. But for sure, a long history of GIs has shown that these general rules are not sufficient, both for producers and for consumers, and they are not sufficient for producers also because there is a need to ensure that they are all complying to the same standard of quality. So this is a kind of internal fair competition between all producers using the same geographical name. Thank you.
Okay, thank you very much, Eric, for your intervention. Always good to hear from the Swiss example. We are familiar with it, and certainly in the Commission, we monitor what's happening in Switzerland as well. I have two questions asked in the meantime. One question is, what type of non-agricultural GIs are indications are accepted by the UIPO? I know there is a list, so we will come back to that question after this session. The other question was actually to you, Eric, if you can give the where to find the PowerPoint presentation of yesterday where you were referring to. Maybe you can look at the chat and respond accordingly. Okay, we have 4 minutes.
I put the link in the chat.
Okay, thanks. We will be cut off exactly at 11:30. So I have still two requests for the floor. I have Bernard. And I also have, let me see, Paula Zito. Paula, you have 1 minute to make a point. I'm really sorry, but 1 minute only.
No, that's okay. I'm from Australia. I'm happy to join in the session. I'm an independent food, geographical indication consultant and a lecturer at the University of Adelaide. Just wanted to quickly say that what Bernard O'Connor said really resonated with me as someone who's working closely on the GI negotiations in the context of the Australia-EU FTA. And that was that I think if you were to go down a trademark CTM or collective trademark protection regime instead of a sui generis regime for non-agri GIs, it would really cast a big doubt over your international perspective and push for GI protection under a dedicated framework. So that comment from Bernard really resonated with me. Just today, I've spoken quite at length about the differences between trademarks and GI protection. They're not the same thing. Sure, they are both badges of origin, but badges of origin about who's made the product for a trademark perspective versus a link to place from a GI perspective and identifying that geographical origin. So as an outsider, I would be pushing for the Europeans to continue down a sui generis system as well for that consistency, but also for that higher end protection as well for products.
Okay. Paula, it's good to know that we have participants from Australia as well. Thank you very much for your position. I think it's very clear. We were obviously involved in the negotiations with Australia, so we take note of your point. I still have Bernard who wants to say something urgently. Bernard, please.
Okay, can you hear me?
Yes.
Okay, thank you. I'd like to come back on 2 points. Gordon Humphrey's question about the missed opportunity. I think it was not a missed opportunity, and I think this is very important. Not only is there an essentially attributable test that we have to address, but in GIs, there's a public policy issue. And the public policy issue is that we as a collectivity are allowing a publicly available name be restricted in its use. And I think that that public policy element requires something different from a trademark approach and a trademark system to address that much wider. I mean, why should I not be able to say I come from Champagne, I go to Champagne, I like Champagne, I can use the name Parma as much as I want, except where the regulator says, no, in relation to this good, it's not.
Okay.
So I think this policy
is kicked out of this meeting, I'm afraid, so then we won't be heard. Many thanks for this final remark. I didn't want to comment on that comment from Gordon, actually, but you did it already, so thanks for that. We have come to the end of this session. Many thanks to the speakers and certainly also to the audience for listening to all of us. We hope it has been a useful session for you. And we will continue the discussions as European Commission, as I indicated in the beginning of my of this panel. We will consult each one of you and we will listen to all the positions of each one of you when preparing the impact assessment. So thank you very much and have a nice day and a good conference. Goodbye.